Institute. The Hinckley Institute of Politics is a nonpartisan institute at the University of Utah. The Hinckley provides an array of transformative experiences for students through internships, forums, and classes. Hinckley forums seek to foster public discourse and civil debate on the most current and pressing issues, bringing in local, national, and international thought leaders. A quick note that we will have an event immediately following this one, so please take any conversations you may have outside. Today's conversation with Senator Mike Lee is the sixth and final of the 2024 Sutherland Congressional Series. This series facilitates civic engagement and civil dialogue as our delegation members speak on a range of critical issues. Constituent engagement matters now more than ever, and these events offer unique, uninterrupted presentations that inform and educate. We want to thank the Sutherland Institute for their partnership on this event, as well as the Senator for taking time to speak with our campus community. Today's conversation will be moderated by Bill Duncan, Constitutional Law and Religious Freedom Fellow at the Sutherland Institute. I'll turn it over to him to get started.
Thank you so much. We're so grateful always for this partnership with the Hinckley Institute, and specifically for this event, we're grateful to Zions Bank for their support of the Congressional Series. And Senator, thank you so much for being here.
Thank you.
We always love to hear from you, and every once in a while I get this chance. I'm grateful for it. We wanted to talk, as you know, about the consolidation of power. I guess that's sort of in contrast to the diversification of power that's intended under the Constitution. What does that concept mean to you? What's the concern that?
The concern animating the authors of the Constitution was that when you have too much power concentrated in the hands of the few, in some cases the hands of the one, there is a lot that can be done that erodes individual freedom, that can present a threat. You remember the Declaration of Independence, we're told that the government has a duty to do certain basic things. They mentioned life, liberty, and the pursuit of happiness in that document. There was also a corresponding understanding that at some point or another, ironically, tragically, but repetitively throughout history, a government whose job it is to protect life, liberty, property, pursuit of happiness, depending on which formulation of John Locke's descriptions of the purpose of government you use, government can ironically become a threat to those very same things. And so the idea was that if you disperse power, if you make sure that no one person, no one group of people can acquire too much of it, we will be better off. It'll preserve liberty and lead to a safer, more prosperous, more sustainable form of government. And our Constitution did a decent job of this. It separates out power. Before you get to the thou shalt nots of the Constitution, the Bill of Rights, you have the structural component of the Constitution, whose job it is to make sure that structurally no one person or group of people can acquire too much power. It does this along two axes, one vertical, the other horizontal. The vertical axis, we'll refer to that distribution of power as federalism, because it leaves most of the power at the state and local level, few powers that are distinctively and specified as national in the Constitution, in Congress and in the federal government as a whole. The other is horizontal. It operates on a horizontal axis between the three branches of the federal government. They are coordinate branches. I don't like to refer to them as equal branches because they do different things, and because the founders understood that the most dangerous of those three branches was the one in which I serve. Because you've got one branch, the legislative branch, Congress, that makes the law. The job of the executive branch, for the most part, is to enforce and implement, execute on the laws made by Congress. And then the job of the judicial branch, headed by the Supreme Court, is to interpret the laws passed by Congress where people disagree as to the meaning. And so the common element in that is the laws passed by Congress. It's also evident that they understood the lawmaking power as the most dangerous of the three because they made us, the branch of government, most accountable to the people at the most regular intervals. Every 2 years, the American people have the power to either retain or replace their members of the House of Representatives. And every 2 years, a third of the senators are on the chopping block as well. So it's evident in the way the Constitution was set up that was its primary purpose, to deconsolidate power.
Yeah. What are the forces sort of feeding into consolidation now? I should ask longer questions so you could drink a second thing.
Since the 1930s, we've been on a steady march toward consolidation of power. And this is, it occurred during the Franklin D. Roosevelt administration, most readily, most abruptly, most rapidly. The biggest single transformation of this occurred during Roosevelt's second term in office, beginning in 1937. In fact, I mark one date, April 12, 1937, as the date that the structural constitution underwent a very significant change. That's the date that the Supreme Court decided a case. It's not talked about very much. It's called National Labor Relations Board versus Jones and Laughlin Steel Company. In that case, you had the Supreme Court for the first time interpreted the Commerce Clause as broad enough to give the federal government power to regulate economic activity, almost any activity that occurs intrastate, doesn't occur across interstate lines, as long as the aggregate economic impact can be felt interstate. They drew the lines around that broadly enough that it can mean almost anything, certainly almost anything that is remotely economic in nature. So all of a sudden, Congress now had the power over labor, manufacturing, agriculture, mining, and in many cases, health, safety, and welfare, even when those things are occurring intrastate. They couldn't do that before, but the Supreme Court said if in the aggregate, the activity that you're regulating has a substantial impact on interstate commerce, then it's fair game for Congress, and we, the Supreme Court, won't step in. You see, prior to that time, the Commerce Clause had been quite limited. It had been focused on preserving Congress's ability to regulate channels of interstate commerce, interstate airways, airwaves, waterways. Today we would say airwaves also. Things or persons moving through a channel or across an instrumentality of interstate commerce. And the other thing that Congress could regulate under that was interstate commercial transactions. Take it back to the founding era mindset. If I'm a Virginia tobacco farmer and you live in Maryland, you buy my tobacco and you're going to use it, I don't know, to make cigarettes or cigars or whatever it is that you do. That neither state law would be deemed sufficient to cover that interstate transaction. They wanted to make doubly sure that the states couldn't disfavor each other through the back door influencing or denigrating one state's end of that transaction. So Congress had that power. So this was a vast explosion of Congress's authority. Had the Jones and Laughlin Steel decision in 1937, had it been achieved through a constitutional amendment, it would have been among the most impactful amendments to the Constitution. But it doesn't get much play, but it really was a significant moment. So the consolidation of power began there, because all of a sudden, there's a lot more power going to Washington. You had a significant transfer of power from states and localities, mostly state governments, which prior to that time had been primarily in charge of labor, manufacturing, agriculture, mining, health, safety, and welfare, to Congress. At almost the same time that that happened, Congress responded to it in an interesting way. Madison had predicted in Federalist 51 and elsewhere that there would naturally be sort of a territorial turf war instinct that would kick in within each branch to cause them to defend their own turf. But some of it kind of flipped post-1937 with the dramatic expansion of the Commerce Clause. For the simple reason, as I define it, Congress knew it would have to do a lot more work. These are a lot of additional laws Congress would have to pass on all sorts of things. Minimum wage, maximum hour laws are a good example of this. But it covers a wide range of topics, including, again, labor, manufacturing, agriculture, mining, health, safety, and welfare. And so, in addition to having to do additional work, Congress also understood that it would be passing more laws. When you pass more laws, you make some people happy, you make other people very unhappy. And so they saw as kind of a protective device that they would start outsourcing some of it. And you started having the onset of the modern federal regulatory agency. Congress passes a law that says something like this: we shall have fair labor standards and practices and fair labor laws in the United States, having found that labor in one state has a substantial economic impact elsewhere. And we hereby delegate to the National Labor Relations Board, or later to the U.S. Department of Labor, the power to promulgate and enforce rules, regulations that carry the force of generally applicable federal law now make that so. So there were a few of these to start out with, and then in the intervening 87 years since then, you've seen that stretch into all kinds of areas. There are more alphabet soup federal agencies that have lawmaking power today than we can comfortably list in one conversation. So what this has produced, sorry, this is a long-winded answer.
It's great, no, great.
It's produced consolidation kind of on two levels. The first level, it's occurred along the vertical axis, where you've seen a shift of power from the states to the federal government, and then within Washington, D.C., within the federal government, you've seen a significant shift of power away from the people's elected lawmakers in Congress, in the legislative branch, over to bureaucrats in the executive branch, most of whom are far enough removed from the president, from the presidency, that you can say that they're unelected and fairly unaccountable. So that has resulted in a circumstance where we now have, I keep these two stacks of documents behind my desk in Washington. One stack is about that tall, and it's usually a few thousand pages long, 2, 3, 4, 5,000 pages in a particular year. It consists of the laws passed by Congress in the preceding year. The other stack is 13 feet tall, and it's typically 100,000 pages per year, and it consists of the Federal Register. For those of you blessed, fortunate, blissful enough to have an existence not knowing what the Federal Register is, I envy you. And I hesitate to burden you with this knowledge of what it is, but it's this annual cumulative index of all the federal regulations that are put in place by these alphabet soup agencies. First is they release them for what they call notice and comment, allowing the citizenry to weigh in and say, oh, we don't really like this, or you might reconsider this part, or we love it, or we hate it, or some combination of that. Then they'll recirculate it a second time after they've responded to the notice and comment process as sort of the final notice to the citizens you're about to be governed. 100,000 pages of new law a year. Now, measured by word length, page length, volume, weight, regulatory compliance cost, almost any metric, the laws passed by the they are effectively laws. So the laws promulgated in the form of rules and regulations by executive branch agencies outweigh, outnumber, out-heft in every respect imaginable those passed by Congress. There's a problem with that because remember the structural constitution, the original part of it. Article 1, Section 1 makes clear that all legislative power in the federal government shall be vested in a Congress, and then it makes clear that the Congress consists of the Senate and the House of Representatives. Article 1, Section 7 then makes doubly clear what is implicit in Article 1, Section 1, which is that you cannot make a federal law except by following a simple formula prescribed in Article 1, Section 7, which is bicameral passage. You've got to have the same text pass in both houses of Congress, the Senate and the House, and then it's got to be presented to the president for signature, veto, or acquiescence. So if you don't follow that, you have not made a federal law. The Supreme Court has a doctrine about this. It's called the non-delegable duty, the non-delegation doctrine. Congress has a non-delegable duty that it can't delegate out. This is informed by a lot of things, including Charles de Montesquieu, probably the single most influential political philosopher on the founding generation, and certainly on those who wrote the Constitution, who used to describe the process by which you allow the same people making the law to be the people enforcing that same law. He described this as tyranny. It's not just that it can lead to tyranny. He said it is tyranny if the lawmakers of a particular law are also the enforcers of that law. And that's one of the reasons why Article 1, Sections 1 and 7 have that impact. So anyway, this is a problem. So we've seen the consolidation happen, reversing to a degree both the vertical protection of federalism and the horizontal protection of separation of powers. We've seen a lot of power thus concentrated in the executive branch, and in that part of the executive branch that is somewhat attenuated from presidential oversight authority. Meanwhile, at the exact same time, you've had further consolidation within both chambers of Congress. And it's occurred through the party leadership structure as you'll have the top Democratic leader, the top Republican leader in the House and in the Senate. I call it the law firm, the law firm of currently comprised of Schumer, McConnell, Johnson, and Jeffries. And the firm, as I affectionately refer to it, is far more powerful today than it would have been 50, 60, especially 70, 80, 90 years ago. Within Congress, you had a fairly distributed power for at least the first 150, 160 years of the Republic. But at that exact same time that you've had this consolidation, eroding federalism and separation of powers, you've also had a further consolidation of power to the point where a lot of members of both houses of Congress think that they work for their respective party leader in their respective chamber. And that's kind of dangerous. I think the founders would have been uncomfortable with that, and we should be more uncomfortable with it than we sometimes are.
Which I guess raises the question, what is to be done about that? And I guess there are really kind of two things that I hope to ask about. One is the REINS Act, and the other maybe is the rules within the body that could make maybe a response to that. You want to talk about the REINS Act first?
Sure, yeah, I'd love to. Yeah, those would both be helpful. The REINS Act, if a genie appeared to me, which would be really cool, if a genie appeared to me and said, you can pass any bill of your choice, just has to be currently pending before Congress, what would it be? 1,000 times out of 1,000, I would choose the REINS Act. It's an acronym, stands for Regulations from the Executive in Need of Scrutiny. The reason I would choose that one is that it would effectively restore the primacy of Congress as the lawmaking branch. It would effectively restore Article 1, Sections 1 and 7. Because the REINS Act has as its principal operating reform that if you pass the REINS Act, these regulations that are known as major rules, in other words, the big regulations that have an impact on the economy, those that impose affirmative legal obligations on the part of the public, and I state that so as to differentiate those that are inward-facing. I'm not worried about the regulations that talk about what time the lights go on in the Commerce Department. But the outward-facing, any federal regulations that have the effect of generally applicable federal law that can impose economically significant affirmative legal obligations on you as a member of the public, those are the ones affected by the REINS Act. And under the REINS Act, those couldn't take effect unless or until both houses of Congress had affirmatively enacted them into law. The other thing the REINS Act does, a lot of people would respond to that by saying, okay, but you would lose a lot of the expertise that you have in these federal agencies if you just made everything run through Congress. That's part of the beauty of the REINS Act. The REINS Act allows us to preserve that, but it gives Congress the obligation, the duty, to have the final say. Because Congress needs to be on the line. If there's an executive branch agency that changes the status quo of the federal law, of federal law generally, in any significant way, you need Congress to have the ultimate say on that. Now, the REINS Act puts it on a fast track so that once the final agency action is written, there's a certain time period that Congress has in order to consider it, and it has to take it up and dispose of it one way or another. This ensures that that would happen. The interesting thing about this, that I choose the REINS Act, it's not even my bill. My colleague from Kentucky, Senator Rand Paul, is the author and the sponsor of it, but I talk about it, I think, more than any other member of the Senate, perhaps every other member of the Senate combined, with the exception of Rand. But we have a good deal. He will take my suggestions on improving it over time, and I'm happy to have him co-sponsor it. I don't really care whose name is attached to it. And this year we added an important provision that would also allow somebody to raise as an affirmative defense for an existing regulation. If somebody goes after you because you failed to comply with regulation XYZ, you could raise as an affirmative defense the duties that I'm being fined for, or that they're trying to throw me in prison for, or whatever it is, are not evident on the face of any federal statute enacted by Congress, consistent with the Article 1, Section 7 formula. That ought to be an affirmative defense one can raise. So anyway, the REINS Act, it would largely restore the balance of power between the three branches back to where it's supposed to be. Again, the lawmaking power is the most dangerous one. It's therefore that if we're going to delegate between one branch and another, it's a bad idea, but it's especially dangerous to hand that over from the sort of the most accountable branch of government and the most dangerous, Congress, over to a portion of the executive branch run by unelected, unaccountable, nameless, faceless bureaucrats, that's dangerous. This would fix a lot of that. By doing that, it's also my belief that over time, it might lead to some degree, a restoration of some degree of federalism. I don't think it would happen overnight. I don't think it would be dramatic. But I think some of that would happen, because if all of a sudden Congress has to start voting on all these things, I think there would be a renewed discussion. Do we really need to be exercising federal authority over every aspect of this? Take agricultural issues or something like that. Maybe some of that would end up going back to the states.
Yeah, very helpful. I want to come back to that in a minute, but to talk about the reforms you've called for in the U.S. Senate processes. I think that's important as well.
Yeah. So the rules are a little different in the House and in the Senate. Both are parliamentary systems. If you're familiar with Robert's Rules of Order, if you were to spend a day in the House and in the Senate, you would see some elements of Robert's rules. But they've both evolved differently to reflect their different structures, their different sizes, and their different roles. The Senate in particular was designed, and we've got rules going back to the very beginning, nearly 2.5 centuries of the Senate's existence. And our rules are designed overwhelmingly to respect, number one, the equal representation among the states in the Senate, the fact that we'll all have the same number. And it harkens back to another provision of the Constitution in Article 5, which talks about the amendment process. There's one type of constitutional amendment that is prospectively unconstitutional. You can't amend that part of the Constitution that provides for equal representation, or as they say in there, I think they say equal suffrage in the Senate. You can't amend that. And our Senate rules reflect this importance. We want to make sure that every member of the Senate gets heard. That's why we have these quirky rules that sometimes people make fun of, the filibuster rule and the 60-vote cloture standard. Simple majority is required to pass most legislation, but nearly all legislation, before you can pass it by simple majority, you have to bring debate to a close. Bringing debate to a close requires a cloture motion. A cloture motion requires 3/5 of the sworn and chosen senators to vote in favor of it, in favor of bringing debate to a close. All those things are designed to create this atmosphere of an open-ended amendment process and equal representation among the states. But in the Senate, over the last 20 years, and this has happened steadily, successively, as the baton has shifted from Democrat to Republican, back to Democrat, back to Republican, back to Democrat again. There's been that succession in that order since about 2000 in terms of who was controlling the majority. Starting roughly with Tom Daschle toward the beginning of, in the early 2000s, he was a Democratic leader. He started consolidating, but it got picked up a lot more after that when Harry Reid became the majority leader. And he started utilizing a process in the Senate known as filling the tree. I won't bore you with the details of that, but filling the tree is shorthand to refer to a parliamentary procedure within the Senate rules that allows the majority leader to block out individual senators from offering amendments to the pending legislation. The quick and dirty way of describing it is he'll introduce an amendment that will replace a comma with a semicolon or change the date by 1 day of the effective date of the bill, some fairly trivial amendment to it, and he'll plug it into a certain place on what we call the amendment tree, and at that point the tree is filled, and at that point you can't have the Senate consider amendments or make them pending to pending legislation unless there's unanimous consent. So what this has done is it's allowed the firm, the law firm of currently comprised of Schumer, McConnell, Johnson, and Jeffries. The four of them will decide more or less on major must-pass legislation, especially spending bills, what they want to be in there. They'll unfurl it, sometimes with hours or at most a few days, for members to read the legislation. Some of these spending bills are 2,000 or 3,000 pages long. And then they'll say, but the government's about to shut down, you got to vote for it. You don't want to be blamed for a shutdown, and so the thing often passes. Meanwhile, they've filed cloture and filled the tree, so nobody can make any amendments to it, even if you discover that there's some really ugly special interest giveaways in there, or even a clerical mistake. It's almost impossible to amend. So what I'm trying to do is not change the Senate rules so much as change the way we interact with the rules, because the rules themselves guarantee this process. The rules themselves recognize no distinction between one senator or another, majority or minority party. In fact, majority leader, minority leader, we're all equal with one sole exception, which is that when multiple senators are seeking recognition at the same time from the presiding officer, the majority leader, by Senate practice, has the right of what we call first recognition. And that's what gives him this power to plug in the tree-filling amendment, thus blocking amendments. So we don't need to, and we couldn't change the Senate rules because it would take 2/3 supermajority to vote. But either party, if either the Republicans or the Democrats start interacting differently with the rules, they'll be in a better position. So I've started focusing on getting Republicans. The reason I'm focusing right now just on Republicans, even though I've got Democratic friends, colleagues within the Senate who feel just as strongly about the need for some of these reforms. But it's more of a live issue for Republicans right now, because unlike the Democrats, we've got a leadership vacancy, a vacuum that's about to occur. Mitch McConnell, who's been the Senate Republican leader for the last 18 years, is stepping down in his position as Republican leader at the end of this Congress. So we'll be electing a new leader, and that's why I've been circulating proposals among my Senate Republican colleagues that at least as far as we interact with the rules, because we're the ones facing this sort of regime change, we need to look for a leader who's willing to use the filling of the amendment tree much more sparingly and over with the overwhelming supermajority of, say, 3/4 of our conference. If either party did that, we would have a much more even distribution of power, and I think we'd be better off as a result of it. I think individual members would be happier as well in both parties.
Very helpful. Thank you. Thank you for that. I want to come back to maybe the REINS Act, because particularly something you said before we started this event. Sutherland's been interested at the state level in trying to call for increased accountability of federal agency guidance. So meaning not the specific rules that you mentioned, but when an agency says, well, we'll consider this compliance with the law if you do the following. And we're not always sure what state agencies are being told by federal agencies. We'd like to know more of that. But you pointed out that the REINS Act could actually probably respond to that concern in a roundabout way. Do you want to maybe talk about that?
Yeah, so what he's asking about are documents that are themselves not law. They're not one of these regulations. But they're documents describing what the agency, what the law enforcement personnel in the agency in question will regard as substantial compliance with the law. And talking about guidance documents is a little bit like talking about executive orders. I have around the state, from one state, one end of the state to the other, in every demographic, people like to ask questions about things like executive orders. They're good, they're bad, what do you think? Most people, when they ask a question about executive orders, they are asking because they hate executive orders. And I tell them that there are as many different kinds of executive orders almost as there are people. There are some of them that are totally legitimate. There are some of them that go way too far. And it just depends on how much authority the executive has to do that thing. Sometimes that authority is made clear from the text of the Constitution. If it's something, for example, that is bound up, inextricably intertwined with the president's role as commander-in-chief, ordering a discrete military movement somewhere. That's handled by the Constitution. That's clear. That's legitimate. Also, if there's statutory authority, a duly enacted statute enacted by Congress giving the president or somebody serving under him to make a particular finding that would justify a particular order or action, that's fine. Guidance documents are the same way. There are as many types of guidance documents from these agencies as there are people, almost. And one form of guidance document can really be just genuinely that. Here are a set of legal obligations that you got to comply with under the, let's say if it's the EPA, the Clean Air Act. And based on the requirements, you're in substantial compliance if you do these things. Doesn't necessarily mean you're out of compliance if you don't, but here's kind of a safe harbor that I think will serve you well. Those are generally okay. But some of them add new obligations almost, and those are tough. But my point is that if you enacted the REINS Act, the guidance documents themselves would be, it would be a little more rare, and they would be less substantive in nature because they wouldn't need to go much beyond whatever it is that Congress had enacted, either in the first instance in delegating the authority to make to issue the regulation in the first place, or in the second instance after they had ratified and in effect enacted whatever regulation they came up with. So over time, the guidance document would become less controversial, and I think there would be fewer of them that would ruffle feathers and cause uncertainty.
Yeah, very helpful. You mentioned earlier the horizontal concern about consolidation. One of the things that I think people who are watching this are wondering about is what happens now that the Chevron deference doctrine, if you want to say something about that, and the new decision of the Supreme Court.
He's referring to the Loper-Bright decision, the Supreme Court ruling issued about 3.5 months ago. And the Loper-Bright decision overturned a ruling from the Supreme Court from the mid-1980s. I think it was either 84 or 85, called Chevron versus Natural Resources Defense Council. The Chevron doctrine said that the federal courts, when interpreting a statute that is enforced by a particular agency, let's go back to the Clean Air Act. Again, the Clean Air Act says, it's a bit of an oversimplification, but it says we shall have clean air. We hereby give the EPA the power to, decide what levels of what air pollutants are acceptable and which ones are going to result in fines and so on and so forth. Under the Chevron doctrine, the EPA's interpretation of what clean air or any other operative provision in the statute would be given deference, an unusual degree of deference. The Supreme Court and the lower courts would defer to that agency and just adopt their interpretation so long as their interpretation was not patently unreasonable. As long as it was reasonable, like they could look at it and say, yeah, I sort of see how you could get there. Then that agency's interpretation of the statute would control. Now, let's say if you're an aggrieved party, EPA regulates the Clean Air Act is requiring you to do something. I don't know, reduce ozone levels below a certain level, and that's going to cause other problems for you. And you say, I've got a problem with that. So you sue the EPA, trying to get the court to agree with your ruling. Under the Chevron doctrine era, so roughly, roughly 40 years, the courts, you would lose. If you were the party disagreeing with the EPA's interpretation of the Clean Air Act or any other statute they're charged with administering, you're probably going to lose. Because they've got smart people working for them, they've got lawyers. Their interpretations sometimes go a little far, but they're usually not going to fall into this category of unreasonableness, so you would lose. A lot of people started pointing out that's not really fair because your status, whether you appear in court as an executive branch bureaucrat or as an ordinary citizen, it's not consistent with the judicial oath or the judicial role historically to treat you differently based on who you are. It should matter based on your analysis of the argument. So anyway, Chevron deference is gone. I think that's a good thing. Different people disagree. But I sometimes worry about the fact that those people who, like me, have worried about the excessive amount of delegated lawmaking power that we've given to unelected, unaccountable bureaucrats. A lot of them view the Loper-Bright decision and the demise of Chevron deference as reason to celebrate in a way that eclipses and obviates the need for reform as far as the delegation of lawmaking power. And I just think that's completely wrong. I think Loper-Bright was decided correctly. I'm glad they got rid of Chevron deference. I think Chevron was wrongly decided. But this is a relatively minor change compared to what still needs to happen. What still needs to happen is that the people deserve to be on notice as to what the law requires of them. The only way you can adequately be placed on notice, I believe, is for the body that includes your elected lawmakers from your state and your congressional district to have met and to have gone through the constitutional process for officially notifying you. Most Americans have neither the time nor the interest nor the mental capacity nor even the awareness to think through, you know what I need to do? I need to subscribe to the Federal Register. I need to make room for this 13-foot tall, 1,000-page long stack of documents each year and review them to make sure that I'm not violating any laws. We're presumed to know what the law says, even though most Americans don't read every law produced by a state legislature or by Congress. It's theoretically possible for you to review or at least get some coverage of that. You're infinitely less likely to be aware of everything the executive branch does. So I think that's the bigger issue that we need to reacquaint Americans to. Getting rid of Chevron's deference is a minor thing. So too is the ruling from the Supreme Court, what's it been, a year and a half or so ago, in a case called West Virginia versus EPA. In that case, the Supreme Court invoked what's called the major questions doctrine. They concluded that this EPA rule that severely limited certain activities that could result in air pollution was so economically significant that it couldn't possibly have been within Congress's intention to authorize that thing. I think it would have been better, and a lot of people are celebrating that too, and assuming that means that there's no need for the RAINS Act, that plus Loper-Bright. Problem with that is they invoked a doctrine of administrative law. There was no constitutional analysis in there. And I think that the more important question that needs to be asked is what are the contours of the non-delegation doctrine? When is the Supreme Court going to invoke that? Because that's actually constitutional in nature. If the Supreme Court were to start enforcing the non-delegation doctrine and actually require, if you're going to impose new legal obligations on the part of the public, you've got to pass it through Congress, they would obviate the need for the RAINS Act. I think that's what needs to happen. There are reasons, though, why this hasn't occurred. The court is loath to get into things it doesn't have to address. People are loath sometimes to sue a federal agency that might have day-to-day regulatory authority over them. And over time, they've also been reluctant to sue because of the existence of Chevron deference and the near certain likelihood that they would lose. So all of this sounds like a headache, and it would create a lot more of a headache for Congress, and it would make things less efficient in Washington because it would be harder to promulgate these rules and regulations that are ultimately designed ostensibly to inure to our benefit, to make us healthier, safer, and happier as citizens. We can't cut the corners when it comes to political accountability because when we do that, we all get hurt. Just so this is an issue that is, even though you probably hear more Republicans talking about it these days than Democrats, it gores everyone's ox at one point or another. And the issue itself is not inherently partisan, especially when you consider this. And I'll close this with this thought. A few years ago, serving on the Judiciary Committee, I and a couple of my colleagues decided that we needed to know how many federal crimes are on the books, how many separate criminal offenses are out there. So we made a formal inquiry of the Congressional Research Service. This is a research arm of Congress whose sole job it is to research fun questions like this one. Took them a while, then they responded to us with a letter that was fascinating. It said the answer to your question as to how many crimes are on the books, and how many federal crimes exist. The answer to that question is unknown and unknowable, but we know that it's at least 300,000. There are at least 300,000 separate provisions of federal law that can land you in prison. And the reason it's that large is because, remember those 100,000 pages per year we talked about? Every year's Federal Register adds more to it. And there are a lot of these administrative agencies that have not just civil regulatory authority, but they have the authority to prescribe, to write, to legislate, in effect, criminal law as well. This really is a problem, and it's got to be addressed because with the complexity is itself a form of subsidy that benefits a small, wealthy elite class of lawyers, accountants, compliance specialists, and lobbyists who tend to inhabit the counties surrounding Washington, D.C. This is doing that while simultaneously costing the American economy an estimated $3 to $4 trillion a year. That's roughly what Americans spend on income tax. But you never see the bill for this, unlike your tax bill. You just know that everything that you buy is made more expensive. And the federal regulatory system has a lot to do with that. The RAINS Act wouldn't get rid of this, but the RAINS Act would temper what comes out of the agencies. and it would give you as a voter much more say in what laws you're subject to.
Well, thank you for giving us so much context for understanding all this. Very, very helpful. I think I understand we need to make a stop, but again, Sutherland's so grateful that you're willing to come and talk to us and share all of this, and a great background. Thank you so much.
Thank you very much. Good to be with you. Thank you.